This is Brad Beira and part of KeyNotion. It's going to be the start of this 1 hour streaming conversation. Ariane is going to do some introductions. I'm going to share my screen with you, and we're going to take an hour to go through the discussion on intellectual property, R&D in healthcare. Ariane.
So ladies and gentlemen, welcome to KeyNotion's webinar with a focus on intellectual property. And today's session is R&D Ownership and GDPR. Today, we're very honored to have Dr. Brad Beira to walk us through this very intricate procedure. And I shall leave it to the hands of the expert here. So the floor is yours, Brad.
Thank you. I'm trying to bring us onto screen, which I see I'm not succeeding very well with just yet, but I'm hoping that will improve in a minute. So hello to everyone, and thank you to KeyNotion for inviting me. Because I don't know all of you and because you don't know all of me, I'm going to be very reliant on you sharing with me questions via the chat. So if you've got questions as we go forward, please put them through. I'll, where possible, answer them in real time. During this journey, the idea is to talk about intellectual property and patent and copyright and medical devices in the healthcare space, and then link that to personal data and the GDPR. So if I'm completely wrong, tell me now. Otherwise, we'll continue as we're going. And as I've said, I'll be responsive to your questions, so please bring them up as they come along. Welcome to today, and it's nice to see you. So as we go forward here, I want to start by, you'll see on the right-hand side of your screen, there is a significantly large medical devices market, and it is a profoundly complex area, and we're going to talk a little bit about that because a lot of change that's happened over the recent years, and when I say recent years, call it 1988 to now, is the provisioning of health and healthcare and medicine increasingly handshakes with technology in multiple ways. So I thought I'd start maybe with an introduction that says intellectual property by its definition, and the definition I'm using comes out of the World Intellectual Property Organization definition. All of the content that I'll share with you, there are references for. So when you have questions and you want to reference, just let me know and we'll share them with you. But intellectual property is the creations of the mind. They're inventions in this instance, literary or artistic works, symbols, names, and images that are used predominantly in commerce in the way that we transact with each other. And it opens up a big debate. And one of those debates coming up now is who makes the creation and what is the purpose of intellectual property? So one of the purposes of the patent system, which is the protection of what you've invented or conceptualized, is to disclose or share technology that over time the public domain can be enriched. And systematically and progressively, we can look at how we've grown in our ability to use technology and make it more accessible. But what it does is it also means that the disclosure of that invention, whatever it is that you've conceptualized, and we'll talk about that on the next slide, is detailed enough that a person with reasonable skill in the art or the discipline can reproduce the invention. It's no good creating a patent that no one else but you can do, because that doesn't then contribute to the purpose of what we're trying to do. With that, of course, because there's commerce involved, the question is who gets paid for that and how does that payment happen? Right now, one of the big debates, and we're going to talk a lot about metadata, and I want to introduce you to a concept now that we'll talk about progressively. And one of those concepts is this: who originates and owns the data? So if you're using artificial intelligence and machine learning, and through the outcome of that machine learning, a new invention is created, the question is then who owns that? Does the artificial intelligence own it? And is the patent attached to them? Or is the patent attached to the legal entity that owns the artificial intelligence? Or is the patent attached to the natural person who represents that? And that interestingly, is a very real discussion that's going on through the World Intellectual Property Organization, especially when it comes to diagnostic creations or the ability to interpret facial recognition in a manner that gives insight into a specific disease condition or patterning of disease. And the group that I have some interest in, who's busy doing stem cell research and looking at the DNA components of the gene sequence, then starts to ask the question, well, when the sequencing is done, who owns that data? Is that data owned by the individuals, and do they have rights to some compensation for the fact that their genetic code is being used, or is that output owned by the originator of the output? So that's a big debate, especially in medicine and healthcare right now. And then that takes us into how big is the industry? Well, according to the graphic that you see on your left, which comes from the World Health Organization, there are about 1.5 million different medical devices available, with 10,000 different types of devices available, servicing at the time of this, but now closer to a $400 billion a year market. That's a significantly sized market that impacts on a huge amount of people. And when we start looking at whether we're doing R&D and what that R&D looks like, and we start asking the question in terms of the R&D, we need to ask, are we investing in a invention? And when we invest in that invention, there's 4 key things that we need to ask ourselves. One is, will this invention be of practical use? Because if it's not of practical use, it fails the first patent test. The second is, will the invention or the creation that we have a degree of novelty? Will it have a new characteristic that wasn't there in the existing knowledge, what they call the prior art in that particular field? So if you're doing, for example, when I started in clinical practice, you had a mercury sphygmomanometer and you had a stethoscope. That was the prior art. Now you can go and you can buy a pulse oximeter that you can put onto your finger. You can switch it on and it will do your SpO2 and it will give you your pulse rate. And if you like, it'll also give you some form of tracer. So prior art migrates as technology migrates. Then the third step is there needs to be an inventive leap or an inventive step that wouldn't have been common practice or knowledge from everyone else in that reasonable technical field. In other words, not only must it be practical and it must be new, it must also be non-obvious. And the fourth piece is it needs to be patentable under law. There are certain things that your country or your region may not regard as acceptable to patent. So when you're starting down a journey of looking at intellectual property, looking at it in terms of what we create out of our imagination, the creation has to meet these basic tests, what they call the pressure tests. So I thought in terms of health, I'd just take you through some of the very basic journeys that have brought us into the intellectual property side of the technology of healthcare delivery. And it started in this contemporary form in the 90s with the Personal Connected Health Alliance. And they partnered up with a group called the Continua, who set design guidelines on what they call medical grade data. Medical grade data then starts to ask the question, who is the data and who owns the data and what does the data look like? So we're going to talk about that a lot when we talk about the GDPR, but the data has to be relevant to not only healthcare, but the delivery of health services and the delivery of medical services, which are often quite different from each other. Into and through that, then, the question was, how do the devices that initially capture medical grade data and record it, then begin sharing it all the way up a value chain? And this is why there are so many different types of devices and so many different sequences of devices, because you need multiple touch points. And they call that fast healthcare interoperability resources, FHIR, and the L7 FHIR are the current standards of interoperability, and we'll talk about that just now. And that was then worked through with something called the Global Harmonization Task Force, and overseen not only in the EU, but globally by the International Medical Devices Regulators Forum. The reason that I start with that in terms of guidelines is because these are the people, or these are the hurdles that one would need to get through when one starts to ask the question, who owns the information? Because the question is then asked, well, how are you collecting that information? What device are you collecting that information on? What series of devices are you using to transfer that information? And are you following the appropriate guidelines and regulations? And an example of this would be, who owns personal data? If you're in the United States or in North America, personal data is considered to be part of your property and is protected under the property laws, which is slightly different in the European Union, where personal data is regarded as a fundamental human right and protected under privacy laws. So if you are interested in a particular definition of data and chat, Spring Open Access Books has a book called The Ethics of Medical Data Donation. And the ethics of medical data donation asks the question of who owns the data. If I disclose data or give you permission to use that data, is that data a gift? Is that data a donation? Or is that data a transaction? And each of those then has different implications in terms of what I'm allowed to do to get that back. So when you're considering who owns health data and what your rights to that data are, whether you're in the digi-pharma area and you're doing clinical trials and research into new efficacy in specific population groups, or you're designing specific outputs, or devices, you would need to consider the data journey, and you would need to consider it in terms of the continuous design guidelines, the FHIR interoperability, and the task forces and their respective regulations. And then an example of some of the most recent acts that have come out. In 2016, in the US, they published the 21st Century Cures Act, which looks at telehealth, telemedicine, telerehabilitation, and technology-based interventions going forward through the next century. The Global Digital Healthcare Partnership was formed in 2018, again, working with the Global Harmonization Task Force and the International Medical Devices Regulators to start looking at what digital healthcare would look like. How is a patient record generated? How is a series of genetic and genome sequencing recorded? And I'll show you a slide on that later. And then ultimately, how does that come together? So the very early forms, the first Data Protection Act came out in 1984. So this is not new. HIPAA came out in 1996, which talks to healthcare information portability and accessibility. And it really asked the question and answered the question, how does a individual's health data get recorded, and when they have access to it, and how does it get used? GDPR form that was amended in 2018 didn't begin in 2018. This is the latest iteration of a series of directives and regulations around the protection of data. And PIA is a Canadian privacy law. Now, I use those because all of those speak about the individual's law. But equally, in each of your territories you list from, you will have Consumer Protection Act. And the California Consumer Privacy Act is an act specifically looking at health-related data as it relates to the protection of the corporate data, not only the patient data. What we're going to talk about now, and it's in bold at the bottom, is what's called Regulation 2017-745 of the European Parliament, which is the regulation of medical devices. Now, what's timely about this is this was approved in 2017 with the view that it would be finally implemented on the 26th of May this year. In other words, Tuesday next week. The interesting thing about it is that it's been postponed, its implementation, because of the focus on hospitals and health institutions being able to provide COVID-related direct and indirect care. And as a consequence of that, we haven't been able to implement it. We will, but not at this point. So that is the journey. So what we're going to do now, if there's no questions, is I'm going to move forward and we're going to talk specifically around these regulations. So to go forward, what I thought we'd do is just start with something very practical and say, well, what does the regulation say a medical device is, and equally what is not a medical device? So a medical device, as you'll see on the screen, is any instrument or apparatus or application or appliance or software or reagent or any other combination used by itself or with others for diagnosis, for prevention, for monitoring and treatment, for prediction and prognosis, for alleviation of disease, or compensation for and support of injury or disability, or for investigation. And I'm not going to read all this, but you can see it there. But in that, what's important is that a medical device doesn't use pharmacological, immunological, or metabolic means in order to provide the service which it's meant to do. It can combine, but the device is the non-pharmaceutical, non-immunological, or non-metabolic related part of the treatment. So when we speak about intellectual property in the healthcare space specifically, we're speaking about it as it relates to the tools and the trade that's used, including the hardware and the software and the ideas. Moving forward from there, there is a series of classifications, whether it's the FDA classifications or the EU CE classifications, that there are three classes or types of devices. The lowest risk devices that pose little or no threat to the patient if used incorrectly, going to those that can cause significant harm to patients if they or the technicians use them incorrectly. And based on that, whether you start with the example that's on the screen of the stethoscope versus the high energy defibrillator, there are different levels of requirement that need to be put into place in order to move forward in creating the R&D component. Where products combine the medicinal product and or the substance with the medical device, those are regulated, and they're regulated in all territories, as you see, with a significant amount of regulation and legislation. The device part, the medicinal products that integrate into the medical device needs to be compliant not only with medicinal safety, but with general safety and performance requirements that should be assessed in the context of the marketing authority, not only for the general product, but also for the medicinal product. So I'm saying this to you because if you're moving into the space where you're looking at investing in R&D and building intellectual property, you need to realize that your obligations don't only remain on the part of the device that you create, but they also go into the general purposes. The requirements for the device's design, safety, and performance must be developed so that they can prevent occupational injuries, specifically in areas where there might be nanotechnology or radiation exposure, and these need to be de-risked and linked. And depending on the complexity of the device and the risk class of the device, the quality management system and post-market surveillance system they need to be both proportionate to the risk class and proportionate to the type of device. So if it's a hospital utilized or health institution utilized device, its QMS would be quite different from if it was an at-home utilized device, although the risks and liability don't change. So going ahead, you heard me speak a little bit earlier about the fast healthcare interoperability resource. This is a map of what those resources look like. So you've got your smart devices, personal health devices, the X73 diagnostic devices, or other smart devices. Those personal health devices need to interface using API technologies and either Bluetooth, USB, or other ISO-related interfaces with personal health gateways. Those gateways are aggregating both individual and population group data, and then that needs to have a service interface with either your health industry or your fitness industry or your wellness industry, and then that goes into a healthcare information system. Now, the rules for the devices or for any data share across these needs to be considered in terms of both the new legislative frameworks for the marketing of these products, plus the existing use and control and liability products under the Consumer Protection Act and under the Health Privacy Act. So as you go forward and design these ideas or implement these ideas, these considerations are quite important. So moving on from there, one of the questions is, well, what are the liabilities that one may face as one creates a device? And the first thing is, and you can see some devices, as a manufacturer, one of the things that you have to have, speaking about the Consumer Protection Act, is you need to be able to have and demonstrate enough financial coverage. In other words, you need to have product insurance, and you need to have public liability insurance, and you may need to have professional indemnity insurances, plus others that you're allowed to have, and enough money in your balance sheet in respect to any claim that may come from an individual or individuals when you release a product to market based on the potential harm that it could cause. There is a provision that's come through in the new regulations that says a health institution should have the rights to manufacture, modify, and use devices in-house. And as long as it's not on a commercial, industrial, or broad market scale, and it focuses on the needs of specific patients, the healthcare institute can take the equivalent device and modify it from the market into what it needs to do. And the regulations then also say, well, what is and what is not a health institution? So a facility that provides clinical care in any form to different tiers and levels of hospitals will be regarded as health institutions. But where certain fitness centers or lifestyle centers call themselves health institutions, they are not considered for the use of medical device modification to be health institutions. And again, the rules need to be aligned. So then we get into, well, what disclosure do you need to make? And you'll see there a fictitious medical device design, but it needs to have, at the very least, a quality management system and post-market surveillance system in place that should be proportionate to the risk class that we spoke about earlier. You need to have risk management and clinical evaluation processes that are interdependent and regularly updated. Now, this goes back to the purpose of the invention. So you would build on your prior art, you would build on your prior knowledge, but your risk management would also need to take the novel, practical, and previously undesigned or previously unpromoted facets, and it needs to include those so that they can be better understood. Generally, the device also needs to bear the CE markings, and it needs to have unique device identification systems based on international guidance where there's a need for tracking. Why is this in the intellectual property and R&D space in this conversation? Is because often when we want to register an idea and we look forward to the intellectual pursuits that lead us to a patent, we don't consider the downstream implications of what the R&D will do in setting up quality management, risk assessment, and financial obligation. So I'm checking, and I see that we have no questions. So I'm assuming that Ariana and I are both happy, and we can continue. So moving on from there, the slide that you see in front of you there speaks specifically to an AME, and whether you move from a patient record back to the biological and anatomical components of what needs to be considered, or you're looking at it differently from a DMR and meta-analysis and metadata component. Either way you go, you've got high amounts of data that need to be correlated and interrelated, and the software that does that in its own right may or may not be considered to be a medical device. So if the software is used specifically for medical purposes, like the collection of metadata in order to create a genetic mainframe, then that would be regarded as a medical device, and it's protected under your IP protection. If the software, even if it's used in a healthcare setting, or in a lifestyle setting or for well-being purposes is general software. That's not considered to be a medical device. So one would need to look when one sets up its medical devices and ask the question, is this for medical use or is this for general use? Because you need to register it and patent it in a different way. And the question how you do that, regardless of where you are in the world, is the qualification will make a decision as to whether this is a device or an accessory. So if you use the software in one territory as a device and in the other territory as an accessory, it still has to be lodged as one or the other. It can't be lodged as both. And whether you're building radiology reports in order to better understand and allow the AI to interpret the lung consolidations to better understand the pneumonia progression as we see currently, or you're doing it to identify fractures, or you're looking for metastatic cancers, or you're consolidating medical records using structured data. The use of a medical record, which is also a non-specific record-keeping system, would then mean that that is a accessory system, not a device system. And those are quite important when one starts to differentiate. So I thought we just pause for a minute now, because we've gone through the landscape of intellectual property and patent, where you've got to identify something new. Then we've gone through very briefly what constitutes device-related requirements. And part of the reason for doing that is because you want to be able to understand, as you invest in your time and as you invest in potentially looking at research, what it is you want to build. At the end of the day, very simply put, we create a device to take information from an individual that we can either use to interpret that individual's specific health needs and or consolidate with others to create societal or public health baselines or private health baselines or utilization lines or an understanding of a non-communicable chronic disease. And I'll use a reference very briefly that's topical to COVID. So World Economic Forum released some information this week that said roughly 150,000 people a day die, of which more than 43,000 die of non-communicable cardiovascular disease. Now, by using data that we get from people through the use of medical devices, it allows us then to consolidate that data, and it then asks who owns that. So I start with data and how does that work in terms of GDPR. So when the GDPR was promoted in 2016 with mandatory compliance from 2018, which is now 2 years ago, there were certain criteria that each innovator needed to, and each operator needed to pay attention. And the first was you needed to understand the exact responsibility as it related to the regulation, and you needed to complete a risk register and understand whether you needed to appoint a data protection officer. Now, in any health-related industry, you need to do all of those. You also then need to ask the question, which is core, of how do you prioritize systems and hold sensitive, and I'm going to talk a little bit over the next few slides on what constitutes data, what constitutes personal data, what constitutes special data, how it's managed. Then you need to, like you would in any business, have your action plans, investigate various technologies that need to be done. Equally, you need to then say, how do we get people? How do we remove data? I choose not to be involved in your new study. How can you forget me? And this is a debate in media platforms on how does one find one's identity. So the key parts of GDPR, and you're welcome to read it through yourself. Article 1.1 limits personal data to that of a natural person. A natural person is a human being in their own right. Legal person, but in to that, it's also corporate entities and identities. one of the questions that we raised earlier is, could an algorithm that designs a new invention be considered to be a legal person? They wouldn't be a natural person, but certainly they'd be a legal person. So that's Article 1.1, saying it needs to be a living person. And in the reference that I made to the ethics of medical data donation, the question is raised, what happens to your health data when you die? You can't bequeath your data to someone else. So what rights do you or your estate have to your unique gene sequence and your past medical history and your potentially unique? So there's no answer to that yet, but it is a debate that's ongoing. And so when we start looking at these genome databases, and to use one example is 23andMe, and then there's the gene biobanks and many of these genetic journeys. The question is, does the data that you contribute belong to you, or does it belong to them? And the wording of donate your genetic data versus give us your genetic data versus we will buy your genetic data has quite a significant difference in terms of what rights you have off the back of that. Also, whether you're on the east or west of the Atlantic has a different thing. So in Article 4.1 of the GDPR, they separate the definitions of data into two types. The data that identifies you, and we'll talk about that on the next slide, as a data subject, and we'll very briefly age, race, gender are some of the examples. We'll talk about that more. And then all other data, like the date stamp or the time stamp or where you are in certain instances at times, and your profile information. So the data that relates to you as a person is split from the data that relates to the geography of where you work, and they treat it differently. And then the third piece of that is Article 9, which is called special category data. And special category data gets more protection. And specifically the protection that it gets is because you're talking now about health data, biometric data, and genetic data. So health, biometric, and genetic data fall into an additional category of protection over and above your personal data. So when we're talking in this health environment and we're talking about medical devices or medical care or the consolidation of the outputs of research, whether it's pharma research, device R&D research, hospital-based utilization research, average care research, that data needs to be split out quite carefully. And so we ask the question, well, what is personal data? So the personal data, as I mentioned briefly, goes into the following things. It's your name, at least, where you live, where you're found, the CAD address, your smartphone, your computer. Those tags that identify you are included in online identified data. Then all your health information, from your birth to your death, everything in the middle of that. Your income is regarded as your personal data, your marital status, your cultural profile, if you have disabilities or not have disabilities, if you've got a history of surgical procedures, that's all your personal data. And that applies for companies and it applies to you as an individual. So personal data plays a big role, and it plays a big role in terms of a couple of additional articles. You have the right as a patient, and one who's creating the R&D needs to be aware of this, is one needs to be aware that the individual has the right to know who's collecting that data and where is that data being collected under Articles 12 and 13. They also have the rights to know where the data is being processed, what categories of data are being moved, how they're being transferred to third parties, and for how long are they being retained. There's also an article that says that the individual has the right to have their data corrected or erased, and there's an article that puts a restriction on processing. So when one invests in R&D that's data specific, one needs to bear in mind all of these components of the GDPR that says, listen, it's your data, absolutely. Now, when does your data become my data? And one of the lessons that we've learned from this recently is if all of us who are on this call contribute our data, and the entity that collects this data combines that data into a new form of data, that new form data belongs to them and we have no rights to that. but we have the rights to our own data and the rights to have our data removed and or the rights to have how our data is used fed back to us within a reasonable time. And that includes everything from your electronic medical record to the procedure that you had, to the e-prescriptions that you get. And there's a flip side to that. And the flip side to that goes in, except when there is issues relating to public safety and public health. And during times of public safety and public health, your government has the right to process your health data if it is in the best interest of community health and well-being, as we see currently. So how do we use that data? And the first piece of using that data speaks to this very real issue of obtaining meaningful consent. And meaningful is the key word here, because we've been working on consent for many years. We just don't really understand where the process of consent begins and ends. The first piece about it is that the organization has to collect meaningful consent for the collection, use, and disclosure of information. It needs to also indicate what in that consent, what personal information is being collected, who will it be shared with, why is it being collected, and what will it be used for, and who will it be disclosed to, and is there any potential harm for me should this happen? Now, the harm issue is a compelling issue, and in the US recently there was a Texas law review that published a case called the theory of risk and harm, and it says if my data is leaked, and we know that data leaks are happening on a regular basis in all industries, from Twitter to certain airlines to certain sites to certain hotel groups to certain hospital groups. Now, when your data gets leaked, the question is, have you been harmed? Yes, your data is there, but until you can show that you've had a consequence of your data being leaked, you don't have a case for loss. And so that's an interesting debate that's going on right now. At what point am I exposed? And at what point in the future might I still be exposed? So in addition to that, you've got various types of consent. And the first type of consent would be a procedure-specific consent. The second would be a general consent. The third would be an open consent. And each of those consents need to have time limits to them. It can't be that I'm giving you blanket consent to do whatever you want with the data at any point in time into perpetuity into the future, because our minds change and our circumstances change and the politics change and the environment changes. And off the back of the environment, if we think back a year ago to where we are now, in 12 months, the general use of data has changed. The contact tracing that we're currently using in the face of this current pandemic means that a lot of the rights to privacy that we held as being our inalienable rights are actually not inalienable, because the public health and public needs for domestic security supersede those. In addition, your consent needs to have a clear choice to opt in and out, and it needs to be an easy consent process that's user-friendly. So that's the consent, and there's a lot to do with consent. Part of that consent is the withdrawal of consent. And earlier on, we spoke about this in the context of anonymizing data. So the GDPR, there's something called Cycle 26, which is an exemption for anonymized data. And it says if the first data category, the one with your information, can be decoupled from where you were at the time, then that remainder, the non-personal data, is exempt from the GDPR, which means an example would be a traffic-related app, or a food purchasing-related app, or a walking-related app that tracks one's movements. If I can remove the name of the person and where they live from where they walked, the route they walked falls into the second category of data exempt from GDPR. Whereas if I said it was a Caucasian male, 50 years old, who lived in Cape Town, South Africa, at this address, walking, that needs to be decoupled. And if it can be decoupled, then the data can be anonymized. Now, this becomes important when designing clinical trials or products for particular population groups with particular risks, hypertensive risks or diabetic risks, or risks that relate to respiratory disease like cystic fibrosis or cerebral palsy. And this regulation, this exemption, applies to all purposes of monetizing data that's produced by people. So your smartwatch and your smartphone and your smart car, that, or your smart technologies at home that allow you to, and have afforded you giving permission to other people to profile you for the purpose of advertising to you, is an exemption from the GDPR. But anything that I can identify you with that says Brad likes cornflakes or Brad likes fried fish, it's the Brad part, not the value of the number of units of fish consumed, that falls under the protection of the GDPR. And so when you read Articles 4 and 6, which is the lawful requirement, with sections 12 to 18, which is what we discussed, the data subject can negotiate with you about what they can and can't allow you to use, and what you may or may not use, and what you can or can't have removed from there. And so I wanted to end with an example of how this works in real time. So this is a slide taken from the American Medical Association digital survey that was conducted first in 2016, repeated in 2019, and published in February of this year. And what you'll see there is there's an increasing amount of practitioners in what they call the early majority. And this curve, the diffusion of innovation curve, I remember reading this in Everett Rogers' book called Diffusion of Innovation back in 1984. And really what this is representing is that the use of apps and devices, both of which fall under the patent and intellectual property discussion that we had, and consequently fall under the regulations we've discussed, were they being used for daily measurements of vital signs? You can now see that the daily measurement of the vital sign falls not only into sections 1 and sections 4 and sections 9 of the GDPR, but they also then require the data interfaces that we discuss in the software and in the device construction to protect patients, protect the data, and to protect the. And so this is an example of where I think we're going over the next couple of years, increased use of devices to allow us to provide better care, to allow us to use big and small and better in a manner that improves access to health, access to healthcare, access to, and under healthcare, primary preventive care, secondary to diagnostic care, and after that, rehabilitative care, secondary to hospital-based interventions. So I want to say thank you very much. We'd agreed in previous discussions that we would do 40, 45 minutes and then open up to any questions if there are. And if they're not, then we're free to pause. Ariana, back to you.
Thank you, Brad, for the very, very detailed presentation. It seems like we have a very quiet crowd today. And how about this? We will be also keeping everyone updated. What I can do is to encourage the participants to send in their questions. They are free to review the whole presentation in order to come out with questions. Would that do, Brad?
That'll be perfect. So I'm available whenever anyone else is available. And I know that you'll make this available as part of your lecture program. Mm-hmm. Thank you very much.
Thank you very much once again, and for taking time off to join us. And thank you very much, ladies and gentlemen, for your attention. So yeah, from the slides, we could see Brad's contact. Either, if I may have Brad's permission, do feel free to connect with him. If not, direct your questions to me and I will compile them and send it to Brad. All right, so
so
Brad,
Ariana.
You know my favorite question. So if that's one takeaway from today's presentation, what would that be?
I think today's takeaway would be that there is a tremendous opportunity to add value as long as you understand the 3 steps. The first step is, what am I contributing? The second step is, how does it fall into the world of what's already there? And the third step is, how will I protect the information of the people who's using it?
So I hope they're all taking notes now. If not, yep. So we look forward to having you with us as always, and I will see you whenever we have our next series.
All right. Thank you so much, everyone.
Thank you, everyone, and I wish everyone a great day.